From the Library of Congress in Washington, D.C.
Hello, welcome back if you're back, and if not, welcome the first time to the third panel on the Copyright Office's roundtables for its study on Section 1201 of the DMCA. This topic is about renewal of previously granted exemptions, and before we get into the meat of the discussion, I just want to remind everyone sort of logistically, if you would like to speak, turn your placards up and we'll call on you. If you can try to limit your comments to 2 to 3 minutes, that will help us make sure everyone gets a chance to speak and we can all engage on the issues. And the microphones, when you're done speaking, please turn it off to prevent feedback. And we also got a request from AV in the last hearing to make sure everyone speaks into the microphone because it's being videotaped and that will help it be picked up on the video. So to start, I think we should go around and say our names. I'm Reagan Smith, Associate General Counsel of the Copyright Office.
I'm Kevin Amer, Senior Counsel for Policy and International Affairs, the Copyright Office.
Andrew Moore, Ringer Fellow at the Copyright Office.
Jason Sloan, I'm an attorney advisor in the Office of General Counsel's Office.
Mr. Band?
I'm Jonathan Band here on behalf of the Library Copyright Alliance.
And I'm Brandon Butler here on behalf of the University of Virginia Library.
I'm Sofia Castillo. I'm a staff attorney at the Association of American Publishers.
I am Gabe Gazares, Government Affairs Specialist for the National Federation of the Blind.
Peter DeCherney from the University of Pennsylvania.
I'm Harley Geiger, Director of Public Policy at Rapid7, which is a cybersecurity firm.
I'm Sam McClure. I'm with the Stanford Law School IP Clinic, and I'm representing the Institute of Scrap Recycling Industries.
Rebecca Tushnet, the Organization for Transformative Works.
Bruce Turnbull, the DVD-CCA, Copy Control Association, and the Advanced Access Content System Licensing Administrator, LLC.
Ben Schaffner, Vice President, Legal Affairs, Motion Picture Association of America.
Andrew Goldman, Knowledge Ecology International.
Okay, thank you. I'm thinking for today's panel, we'd like to roughly divide the discussion into the first half focusing on the need for some sort of renewals, whether this is a presumption of renewal, a burden shifting towards someone opposing renewal, a general streamlining of a process, whether it's administrative or statutory reform, and then getting into specific models if possible. I realize for this topic, I think it might be a case where the devil's in the details. The registrar has stated both in her recommendation to the last rulemaking and in her testimony to Congress that the public record supports amending Section 1201 to make it easier to renew exemptions. She recommended congressional action to provide a presumption in favor of renewal in cases where there is no meaningful opposition. And in the comments that the Copyright Office has received, there seems to be, I hate to jinx myself by saying it, but some consensus that doing something would be permissible and advisable to deal with repeated exemption requests. But the comments definitely diverge in terms of what that would look like and how the concerns were going. So again, I'd like to open up with a pretty broad question of what would your proposal would be, or what are your concerns with doing something to make it easier to facilitate the renewal of repeated requests for an exemption. Mr. Schaffner?
Yes, first of all, I just want to agree with you. I don't think it will jinx the panel to say that there actually is a remarkable degree of consensus that as to previously granted exemptions, there should be some sort of streamlined process. There's too much of it. It's really a waste of time and effort and burden on both the proponents and the Copyright Office staff itself to have to go through a full process when there's really no meaningful opposition. So again, broad consensus that something should be done, and even within the details, I don't think there are dramatic differences. As Bruce and I were talking over the lunch break, we were wondering exactly how even a group of opinionated lawyers are going to be able to fill up a full hour and a half on this particular topic. But just a couple points as to how we think this should work and sort of why we think that our particular proposal makes sense. As we see it, the way it would work is that proponents of a previously granted exemption who seek renewal should make some very simple filing. We're talking a page or so, stating that they would like the exemption to be renewed, and essentially to show why they think it should be renewed. Again, we're talking about a very simple 1 or 2 page filing. Then there's a period of time where if an opponent wants to come forward and say, well, actually, we do wish to oppose this, and briefly, here are the reasons. We think there's still a substantial debate about whether this would, the exemption should be renewed. Then it would go shunt it off back into the regular process. But again, if nobody came forward to offer any meaningful opposition, the Copyright Office, under the existing statute, could then just go ahead and say, get out their renewed stamp and be done with that particular request for an exemption. The one thing I'll say before ending is we do think that this proposal should be limited to renewal of the particular exemption that has been granted. And in practice, that is actually what's happened. It's been the exceptional case, almost a rarity, where there have been opponents to previously granted exemptions. I know from our perspective in particular, this last round, there were previously granted exemptions that we had opposed in the past. Some of those we've lost on. But if people came back and asked for the renewal of the previously granted exemption, just as a matter of fact, this is no secret, you can just look in the filings, we did not oppose any of those exemptions. We would not want our proposal, however, to apply to requests for expansions of previously granted exemptions. If there are new things that people are wanting to do, we should go through the regular process, and again, the burden should remain on the proponent of the exemption to make their case.
Okay, thank you. Mr. Goldman?
Sure, thanks. So KEI, I mean, we believe that there should be presumptive renewal of previously granted exemptions. I think what we would say just in response to that is it doesn't make sense to continue to put the burden on the party that's already received the exemption. Once the exemption exists, the burden should shift to the copyright holder. And I think in the previous panel, we heard a lot of examples of just the waste of time, the difficulty of understanding the process for the parties that are seeking the exemption, and then to continue to have to go through that process just seems wasteful and confusing, especially where you have exemptions that have been granted that have been unopposed, as has been the case with the exemption for literary works distributed electronically to be accessed by persons who are blind, visually impaired, or print disabled. The exemptions, I think we've seen over time, and I think this was referred to by Krista Cox in the last panel, we've seen them get increasingly more complex and lengthy. In 2010, there was a 100-word exemption for audiovisual works, which then went to 752 words in 2013. And I don't think that this process should be, and KEI does not think that this process should be so complicated and so burdensome for people that are trying to make non-infringing use. And this is a complicated segment of the law, even if you have a JD, and you should not have to have a JD in order to have the exemption and continue to have it. Thanks.
Thank you. Mr. Band?
So I'd have to study what Mr. Scheffner's proposal in greater detail, but I think in broad strokes, there's a lot of, I would agree with a lot of what he said. At the highest level, I agree that there's an awful lot more that the Copyright Office itself can do right now without any amendment of the Copyright Act. I think way too much deference has been placed on one sentence in one committee report that actually was directed to a different rulemaking. Okay, it was a rulemaking that was going to be conducted by NTIA, not this rulemaking. And so there's no need for you to pay any deference at all to that one sentence. But even if to the extent that you want to pay some deference to the de novo sentence, it's about a de novo determination, which is sort of like what you guys have to do, or actually what the librarian has to do, not what we have to do. I mean, you could easily say, okay, if you want a renewal, you can just have the whole administrative record from the previous rulemaking just incorporated by reference, and then the process in terms of the, what the registrar's recommendation and the NTIA advice and the library, I mean, that maybe have to be somewhat de novo, whatever that really means. But again, I don't even think you really need to pay that much deference to that one sentence. But I think, so that really could streamline the process dramatically. And so I agree with, Mr. Scheffner's idea that, if we want a renewal, we can just do maybe not even a page, maybe a paragraph or a sentence. And then if, even if, I would disagree that if there is a opposition, then it kicks back into the normal process. I think it should be still somewhat of a truncated process. I mean, I think all of the evidence that was previously submitted should be incorporated so that no new evidence needs to be submitted. And so, and then, if we as a proponent want to propose additional information, we can. And if the opponents want to propose additional information, they can. But still, the whole record should be included and considered by the register and the librarian going forward.
And I think just to kind of pick up on that and follow up, we'd be interested, as others answer this question, if you agree that under current law there is some flexibility for the office to, for example, consider evidence from the prior proceeding. Is anyone aware of any other sort of administrative processes that might provide an analog where the evidentiary record from a prior proceeding could be incorporated? That would be helpful for us. I think Professor Decarny.
I don't have an answer to that specific question.
That's fine.
I was just going to say that it's actually, time doesn't stand still, technology doesn't stand still, uses of technology doesn't stand still. So it's very unusual to have a renewal that would look exactly the same as the exemption looked 3 years ago. But I don't think that's a reason to throw out the proposal. There may be another way of saying we want to start where we left off last time and then think about additions or changes. I'm not always even sure that they're additions or expansions. Sometimes it's just an updating of the existing exemption so that it accounts for current states of technology and the way that it's used. And so maybe there's just another way of doing it so that we don't have the same conversation from the beginning. We don't start at the beginning line. We start where we left off last time.
Thank you. So I think there's two issues, what Kevin has followed up on and also what you've just raised in terms of expanding the exemption, but I'm wondering if we can stick first to see if there's some consensus around roughly what Mr. Scheffner proposed in terms of a short form filing prior to the rulemaking proper. And I wonder, Mr. Casares, is that something that would work for your organization?
Sure. So I think that that proposal would definitely have to be flushed out even more because, as everybody has already stated, what we have now is burdensome and time-consuming, particularly for the community that I represent, people who are blind and print-disabled. If you take a look at the record of the last comment period, how many comments were submitted by organizations or groups representing people with disabilities, and it's demonstrably lower than some of the other groups, and it's because of the burdensome evidentiary requirements, the inconsistencies that they have been throughout the triennial cycles. And I think that coming up with a sensible proposal like the one that has been proposed would be an interesting conversation to have. I think particularly for the disability community who really does rely on these exemptions.
Thank you. Professor Tushnet?
So I want to agree with Mr. Band and Mr. Goldman. I think they're right about the current law. There's flexibility, and it's not just because of the legislative history. So, for example, even if you wanted to take de novo as if it were in the statute, de novo actually has a perfectly respectable meaning for courts that doesn't actually require any additional factual development. It just means de novo, right? We don't do new fact-finding when courts do de novo review. And I would think that at the very least, that would be free for you to do. And one thing that I have often thought about actually in this connection is, what is the difference between saying we would like to incorporate by reference our submissions from the past 3 rounds? I mean, surely that's a legitimate way of submitting evidence. I mean, you have it. I mean, I can give you another copy if you want, but it seems like it's still evidence to me. And so I see absolutely no barrier under the current regime to formalizing that and acknowledging it rather than requiring us to go through. Because what we did, we just reprinted everything and stuffed it in the appendix, just because what else can we do?
And then you also updated it too. I mean, do you think that the statute does require some sort of showing of freshness of evidence?
Absolutely not. We did it because of the current interpretation of de novo, and we feared, that the office would not see it as sufficient if we. The other thing I want to point out here is that there's interaction here with the proper definition of classes. So this is something that Professor DeCherney talked about, that if you get a definition right in certain ways, it may not need to be updated as often, and therefore there can be less thesaurus around the edges.
Thank you. Mr. McClure?
Sure, yeah, thanks. Definitely broad agreement with what's been said, especially what Professor Tushnet said about how I think the renewal process can be streamlined through both legislative history and the statute. There are definitely arguments for that. I think there's a lot of latitude there. 2 maybe small points that I think would be really helpful to have a discussion about. One, the filing, the showing by the proponent. We actually believe that it should just be presumed renewed. That there shouldn't necessarily be a burden on a party to file some kind of statement. I don't know if that's serving some kind of notice principle, but I think there's enough notice sort of throughout the rest of the process that if we just say that this exemption is presumptively renewed, then we can move forward with maybe some sort of process that mirrors the existing exemption process for where opponents would be filing a meaningful opposition. And then with regard to the meaningfulness, I think there was some statement made that as soon as an opponent files opposition, it's sort of kicked back into the original process, and we just wanted to clarify and ensure that there's some sense that the opposition is meaningful, of course, and that maybe, to the point that was made by Professor Tushnet, if there is this prior evidentiary record that is just getting kind of copy-pasted into the new process, that the opponents of the old exemption would have to say, okay, something significant has changed in the facts here, to support an overturning of that exemption.
So you've raised this other idea, which is, as the registrar also suggested looking at, that there should be a presumption of renewal that would just become automatic. And before we get comments on that, or maybe people could kind of on that and compare and contrast to what Mr. Sheffner proposed, which would be that the proponents would make a very short filing, but it would still be a mandatory filing from the proponents to show, very briefly why an exemption was still needed. So, Mr. Turnbull?
Yeah, I think I'm in agreement with my colleague, Mr. Sheffner, on this, and to expand a little bit and capture some of the other comments that have been made. I think the notion of bringing forward the evidence from the record or referring to it, you all have maintained the online capability to go back and see previous comments and previous hearings and that sort of thing. And I mean, I don't know that we even need to put people to the burden of copying it with their current filings. So, we'd be okay with that. I do think under the current statute, you would need to have a filing to say, yes, we want the renewal of the exemption as opposed to the presumption. And it seems to me that that's a minimal enough thing, and whether it's a sentence or a paragraph or a page, none of us are talking about anything terribly.
It's only by the hour.
Yeah, right, by the word. So I don't think that's a big burden at all. And I think the other point, Professor Cherney talked about the differences. Again, I think the notion, at least as far as we're concerned, would be that with regard to exactly what was done before, if there's no opposition, no meaningful opposition to that, that simply goes forward. And the argument then becomes about the difference, not about what was before. You don't go back to the whole issue if there's opposition to the difference. And I think, again, that would help both to streamline the process and also minimize the burden on either party in terms of bringing evidence forward.
Okay, thank you. I think next we'll hear from Mr. Butler. And I think to put some more gloss on the question, the statute requires that the librarian makes a determination in a rulemaking proceeding that persons who are users of a copyrighted work are or are likely to be in the succeeding 3-year period adversely affected by the prohibition on circumvention. So when I hear questions of we could have just one sentence or one paragraph, I wonder, is that enough under the current statute? Taking Mr. Van's comment, he thinks there's perhaps more flexibility permitted to say, is that enough to say this is a determination in a rulemaking proceeding? And also, generally, what are your thoughts to what Mr. Sheffner has proposed?
Great. So I just wanted to raise a couple of points. One is I think that this process should be very, as it has been, and as we've heard a few times today, cognizant of who are the participants and how are they represented. And so, there's big collective action problems on the proponent side oftentimes. For example, in my clinic, it's a different student team every 3 years. And the way that we structure our retainers with our clients is that representation ends the minute this process ends. So there's not a student attorney that is continually responsible. It's sort of, I guess, faculty, and then faculty turnover, and staff at nonprofits turnover. And so there's a kind of trap for the unwary problem I'm worried about in terms of having to even file a one-pager. If you're a small nonprofit, or if you're someone who had the help of a clinic, what will you do in 3 years if the person who supervised that student team is at the University of Virginia instead of here? And so I'm just worried about that. And one option, I think, is, we file trademarks, for example, and our trademark clients operate under the same system where, we represent you for X amount of time, and then we need to let you go because our students leave. But we still have a kind of institutional email address that's on file with the PTO. And when events happen that might be relevant to the clients, we make sure that we're on that notification list. So maybe there could be a notification system that is where when the 3 years comes up, you let the representatives of past proponents know, hey, the 3 years are coming up, and that can be an address that everyone would keep alive. I think that would be fairly simple, and there's no good reason to
Right, so the office could sort
try.
of say, give me your email address if you want to for the form, and send out something
Yeah, exactly.
in advance.
Yeah, and then the other thing I just wanted to point out is that there's substantial reliance on these exemptions in pretty big institutions. At this point, the educational exemption's been granted and renewed for long enough that at universities, they've been buying DVDs, and part of the value proposition of a DVD is that we will be able to cut clips. And so that's an investment. I'm told that UVA spends about $30,000 a year buying DVDs. So in 3 years, that's almost $100,000, where the hope every time we buy that DVD is that faculty and students can make lawful uses in accord with the exemption. So that's another great reason to do the renewal, is that there's so much reliance built up.
Is that a reason to do the renewal, or is that a reason to perhaps participate in our fifth panel and say there should be a permanent exemption for
absolutely.
education? But the reason I ask is that Congress is pretty clear that this is intended to be a fail-safe mechanism, that it's intended to allow the office to keep their pulse on technological developments and react. And so it cuts both ways, that an exemption granted might become ossified or overtaken by market events.
Yeah, no, make no mistake, this is sort of a third best solution, right? First best is the Unlocking Technology Act, second best is a permanent exemption, but third best is a renewal. And I agree that the concerns that educators have in particular don't tend to actually become overtaken. So for example, VHS tapes. There are tens of thousands of VHS tapes that have never been issued on a subsequent format. And those tapes are actually still being used lawfully under fair use. They're being digitized and used in clips in the same way that DVDs are. I'm sure, like morally certain because of the way media works, that the same thing will happen with DVDs. And so we will always, I think, need to decrypt DVDs in order to make clips. I think that's just, that's in the nature of things, the way media grows and changes.
Ms. Castillo?
Yes, I have sort of 3 points to discuss. The first one is, in general, AAP is open to some form of streamlined proceeding, or in general, we are in agreement with most people in the room, seem to be so far in terms of favoring some form of, oh, I'm out of words.
A presumption of.
No, not exactly a presumption, but some form of improving the renewal process so that it's easier. But one of the things that I think might be problematic is the suggestion that there should be a complete burden shifting so that it is the opponent who has to oppose an exemption that has been already granted for renewal. The problem with that is that the opponent doesn't necessarily have all the evidence necessary to show that the exemption is no longer necessary, or has been used in the past 3 years, or what the likelihood of adverse impact will be in the next 3 years. The other thing is that for any form of streamlined proceeding of previously granted exemptions, the exemptions that are renewed should be the exact same exemption that was approved before. If there are any changes, of course, there can be some form of middle proceeding, and I think it has been suggested before that it's not exactly kicked back to what we have today, but something in between for additions or changes to previously granted exemptions. So I think it's worth for the Copyright Office to sort of contemplate having several tracks or something along those lines. And then the other issue I've heard is that there seems to be some favoring of an automatic renewal presumption. And the problem with that is that then that would be very similar to having permanent exemptions. And that is something for the panel tomorrow. But for purposes of renewal, I think it's important to take into account that having this proceeding every 3 years is helpful to account for changes in the marketplace. And if we have an automatic renewal presumption, then that would sort of take that away.
Thank you. Mr. Geiger?
So we hire a lot of security researchers and white hat hackers. And we also work with a large number of independent security researchers that we do not employ. And most of these researchers are working either solo or as part of some sort of very small shop. And most of them, the vast majority of them, do not possess the requisite legal expertise to even deal with cease and desist letters telling them to stop their research, often making vague claims about DMCA, let alone for engaging in the temporary renewal process. So from our perspective, we absolutely support a presumption of renewal. And it sounds like these are the fault lines based on what the rest of the panel has been saying, and I'll say where we come down on it. When it comes to the burden of the initial filing, Mr. Sheffner had suggested that it should be the proponent of the exemption that makes that initial filing. We would support an automatic renewal. And the idea that it would just be one page, I'm not sure is going to hold for very long. This is one reason why I think that the opponents ought to be the ones that make the filing. That one page could very well expand unless it's restricted to a single page, and then every word on that page is going to get litigated, and you will once again need legal expertise in order to make a good filing, one that does not trip you up later down the line. When it comes to the losing that presumption of renewal. We've talked about whether there should be meaningful opposition that cancels the presumption of renewal. And I don't think that that's the right standard, because if anybody objects, which was Mr. Scheffner's original proposition, if anybody objects, then be shunted into the original process again. But as we have seen in previous rulemakings, the same arguments are trotted out over and over again. There's no reason why those same arguments would simply not be trotted out again and then cancel the presumption and shunt you back into the original process. And then what really is a presumption worth, except for something that is completely unopposed? When it comes to, so instead of meaningful opposition, I think that a better standard would be whether or not there has been some sort of material change in circumstances. We've talked about changes in the marketplace, changes in technology, and so forth. Those types of changes are different than simply meaningful opposition. I think that that would be a better standard.
So go ahead. So the presumption would kick in automatically, and then just the burden automatically would be on opponents to establish a material change in circumstances.
Yes, that's right. And I'll take it a step further, which is to say that two things. One, if we're talking about an expansion above and beyond the original exemption, we think that the process ought to be then about that expansion, as opposed to the expansion plus the original. And lastly, and this goes to the evidentiary standard for the exemption, not just a renewal, we don't think that non-copyright interests that go beyond protecting copyrighted works or protecting the availability of copyrighted works ought to figure in to the denial of the exemption, including the rebutting of the presumption that you would get the exemption again.
So I think that leads right into another question. As you indicated, the proposal that Mr. Scheffner outlined, as I understand it, is premised on lack of opposition, lack of meaningful opposition, or some variant of that. We have another alternative, which would provide that the presumption would kick in automatically. I wonder if panelists have views about which model is preferable, and if the standard is meaningful opposition, what would that mean exactly? Would the Copyright Office have some discretion to sort of to make a determination as to how meaningful an opposition is? We'd be grateful for your thoughts, Mr. Scheffner.
Thank you. So we do oppose the idea of a presumption of renewal of previously granted exemptions, and Ms. Castillo touched on some of the reasons, but I want to expand a little bit. First thing I'd say is don't necessarily listen to my reasoning, but I would just point you back to the Copyright Office's own reasoning back in the rule issued on October 27th, 2000. And I won't repeat what the Copyright Office wrote here, but in sum, the Copyright Office looked at general principles of statutory construction and administrative law. And again, summarizing, essentially what the Copyright Office concluded from looking at the legal authority is that essentially when you have a statute and then you have exemptions to that statute or exceptions to the statute, again, those rules of statutory construction and administrative law say that, one, the exemption should be construed narrowly, and two, that the burden should be on the proponent of those exemptions. So again, the Copyright Office concluded this based on sound legal reasoning back in 2000. I don't think there's been any change in the general principles of statutory construction or administrative law that have changed. That said, I want to emphasize that the discussion we're having is largely academic for two reasons. One is, as I stated previously, there, at least in the last round, and I think this is sort of becoming the practice, there is virtually no opposition to previously granted exemptions. Just as a matter of fact, even those who previously opposed an exemption are sort of looking at the state of affairs once it's been granted and saying, you know what, for whatever reason, whether we can't come up with a showing of harm or just a sort of political recognition that the Copyright Office is not likely to reverse a determination they've made in the past, we're simply not opposing them. And the other thing I want to emphasize is that although the burden should remain on the proponents, we're only talking about a presumption here. So if you had no presumption, you assume both sides start at 50-50. If there is a presumption of non-renewal or not a presumption in favor of renewal, the proponents start at 49. and the opponents at 51. But again, as long as they make some sort of minimal evidentiary showing that they are entitled to that exemption under the statute, they will overcome that presumption, and therefore the Copyright Office would be entitled to get out their rubber stamp of renewal.
Mr. Turnbull?
I think I'd agree with pretty much everything was just said, but let me just add that I mean, truly, it seems to me that the burden on making the initial statement that, yes, we want to renew, I mean, it could be a checkbox on a form. And if the Copyright Office emails that form to the prior proponent and says, do you want to renew exactly what you got before, and you check the box, I mean, as far as I'm concerned, that would be a sufficient filing. I really did not mean this to be any kind of burden. I mean, that's the, but it seems to me that under the statute, you do need to go through the process of actually getting a request. You can use, as we said before, the prior evidentiary record as the basis for that. That satisfies the requirement that this be done in a rulemaking, it seems to me. And the opposition, I'm sort of trying to come up with. I understand the point about making the same argument all over again. That does seem to be a waste of everybody's time, except maybe for the lawyer who bills by the hour. But so there's some kind of changed circumstances, changed argument. There was a change in the law that something that people thought was fair use was found not to be fair use, or there was an abuse of the prior exemption, or somebody actually came forward with a circumvention tool that turned out to be a huge problem in the marketplace. Those are the kinds of things that I can imagine often as an opponent coming forward and saying, hey, you really ought to look at this again. Those are the kinds of changes that I would see as needing to be brought forward. That's not a matter of presumptions or burden shifting in my view. It's just a matter as practical, as Ben said. As a practical matter, DVD-CCA has not opposed the previous exemptions that were granted, and I don't foresee doing so in the future. Again, absent some specific change, and there I think we ought to be able to come forward and say there's been a change and here it is.
Thank you. Mr. Brand, do you want to speak, following up on this question of whether, the ease of showing whether there's changed or unchanged circumstances is sort of a precondition to renewing an exemption?
Yes. So it seems to me that to some extent this whole discussion of, presumptions and burden shifting is not really appropriate to a rulemaking. I mean, those are terms that are much more appropriate to an adjudicatory proceeding. And this rulemaking has, for whatever reason, has over time taken on more and more of this adjudicatory quality to it, but it's really not necessary. It seems that, getting back to your earlier question about, yes, the statute would require the librarian to make a determination that there's harm is occurring or is likely to occur. I mean, to some extent, that can, in this renewal context, can occur if the check box says, do you want to renew this exemption because you are being harmed or are likely to be harmed over the next 3 years? And then that would seem to me, just on its face, that statement plus the incorporation of the administrative record from the previous would be sufficient for the librarian on the basis of sort of making, looking at it. I mean, I'm not sure I would go, I think if we just, the rubber stamp is probably might not pass APA muster, but that the librarian, based on that record, would say, well, a good case was made 3 years ago. There doesn't seem to be any changed circumstances. These people say that they're likely to be harmed again, okay, I will approve it. I don't think we need to start getting into, burden shifting, presumption, all that kind of stuff. Now, it is conceivable that someone will come out of the woodwork and say, no, I don't want this renewed. And again, we're talking, and I agree that if we want an exemption expanded, that's on us to talk about why it should be expanded. But if we're just talking about, the renewal the renewal of the existing one, then, conceivably, if someone comes in and says, no, it shouldn't be renewed, that's something that the register would look at in the recommendation and to see whether they made a sufficient, whether what they said was sufficiently compelling about changes or whatever, but inconceivably in the notice soliciting comments, you would explain the kinds of things that you would be looking for. But again, I don't think we need to start talking about evidentiary burdens or anything of the sort. I mean, these would be things that would be considered in the course of this determination in a rulemaking context as opposed to an adjudicatory context.
Well, so I think with check the box and rubber stamp, we've lightened the workload of the Copyright Office, but I think from
which is our objective. That's why we're all here.
That's great. But from a rulemaking perspective, I wonder, can we speak a little bit more about, whether the office has previously said that a declaration of unchanged circumstances could be considered in renewing an exemption, and other ways we could use that or build upon that to make the renewal of previously granted exemptions easier. So, Professor Tushnet?
You asked earlier on, and I think this is another version of it, whether a one-page statement could meet the statutory burden as the office has interpreted it. And I think the answer is absolutely yes, right? If it says nothing has changed. In other administrative proceedings, facts that aren't contested are routinely accepted, even without going back to the bedrock. I mean, certainly, if you do want to look at the PTO as a model, in fact, you can rely on things like a statement of 5 years of uncontested use. The PTO can actually rely on that not just to say that there's been 5 years of uncontested use, but that has a legal consequence that the mark at issue has developed secondary meaning. So it's actually perfectly standard to accept things like that. Now, I also would like to say a little bit about the meaningful opposition question. So this is just specific to our experience with the remix exemptions. What we hear in the remix exemption proceedings is the statement, our arguments about the facts and the law apply to both existing and proposed exemptions, but we do not oppose renewal. And if you go back and look at, you'll see that structure in basically everyone's opponent's comment. And one question I would have for this meaningful opposition standard is, how are we going to interpret a claim like that? Does that represent meaningful opposition to the existing exemption, since it's an argument against it, we not taken to its logical conclusion? And let me just with my law professor hat on, so if the evidence is relevant to both the existing and proposed expansions, then an adjudicatory model does allow you to ignore that fact because parties are allowed to make strategic concessions, right? But a rulemaking model might not. And so one thing at issue here is to decide what this proceeding will be. And once we have a better grasp on that, some of the answers will follow. But I think right now we actually are, as Jonathan was saying, we go back and forth. Some is adjudicatory, some is rulemaking, and that's part of what makes it difficult. And then relatedly, just again for the remix specific, as in terms of meaningful opposition, as a practical matter, I expect that the opponents will always come back saying, hey, there's a new screen cap program out. There's a new processor, it's faster, it's better. But
then you've heard next to you, the general opponent saying they don't do that. They don't oppose the existing ones.
But if I encourage you then to go back and look at the comments, because they're absolutely right. They're saying they don't oppose it. But the arguments they make, and they say this too, the arguments they make apply to both the existing and the proposed extension, but they are not opposing. And so one question for you as decision maker is, what consequences ought that concession, if it is a concession, have? Right? Does that count
Sure. And I mean, just since our goal is to build consensus, I think in the past, the office took them at their word when they said they were not opposing and held them to that, as opposed to saying, well, some of your arguments on the expansions would apply
Well,
to the
so
existing.
I understand, and my point is simply that makes sense in an adjudicative model. But if you're really thinking about this as being a rulemaking fact finder with independent fact-finding obligations, then that is an intrusion into the model, and at the very least, we should talk openly about that. And this is somewhat of a statement against interest, I admit, but I'd like to know the answer.
Mr. McClure?
I'd just like to make one more quick comment maybe about the idea of presumptive renewal, which is that an organization is tied to this if you don't presumptively renew, then you have one organization, the original proponent, perhaps being tied to this exemption, process after process. And I think a point was made by Mr. Butler and Mr. Geiger that once the exemption is granted, it's something that benefits the public at large who falls within that class, right? It shouldn't have to be one organization that comes back and year after year sort of lives in fear that someone is going to present meaningful opposition, and then they're going to go back into this 100-hour, 1,000-hour process. So to the extent that an exemption would be presumptively renewed, the burden on that particular organization would be relieved.
Thank you. Mr. Professor Deckerney?
I just want to expand a little bit on Professor Tushnet's point. The structure of the comments I've seen from the DVD CCA, the MPAA, is always, in theory, we're not opposed to the renewal, but we think it can be limited in these 10 ways, 20 ways. And we actually spend a tremendous amount of time refuting each of those ways in which would be limited, and much of the hearing time is spent discussing those. So even though it says it's not an opposition, it is, in fact, opposition. Just one other structural issue, which I know has been mentioned in comments but hasn't come up here, I just wanted to bring it up, is if you do a brilliant job drafting the previous exemption, then you've actually eliminated this problem for 3 years. And so it's hard to show that the harm that existed 3 years prior still exists because the problems have been solved. You can show that the exemption's been made use of or caused problems, led to infringement, but you can't show the exact same harm that was there before.
So you think you can't show unchanged circumstances?
I mean,
Because
that's
you've
true of
made
life
use
in
of the
general, yes.
Thank you. Mr. Turnbull?
I think the point's been made about the nature of the filing and the comments, and are fair points. And I think the office has appropriately taken those as was indicated. I think the procedure that we're now talking about would probably eliminate that approach to the comments, because you'd be forced up front to either say, there are meaningful differences, there are changes, or not. So I think that the procedure would naturally eliminate that sort of problem. I think and then would force us to say, well, gee, is there really a change that we want to argue here with regard to the old exemption, or is it something where we want to say, no, that we're only going to argue with regard to whatever the change is? And I understand that and the points that have been made are fair on that. The other thing is, I threw out the sending an email to the previous applicant with a checkbox. I wouldn't rule out somebody else coming in and saying, I've been taking advantage of this and I want this renewed, even if the organization that originally filed. I didn't mean to preclude that. I was just trying to be helpful in making it easier. So I think anybody who can represent that they are taking advantage of the exemption and believe it should be renewed as previously stated ought to be able to make that application, and then we would have to decide whether there's a reason to oppose.
Mr. Cazares?
So from the perspective of people with disabilities, I know that the National Federation of the Blind fully supports presumptive automatic renewal. I think many at this table remember the 2010 cycle when another disability organization, the American Foundation for the Blind, came very close to losing the exemption that they had previously renewed. Because of evidentiary requirements. So I think there's something to be said for taking into account the points that have already been raised by the copyright staff and other panelists about the statute and the limitation that the librarian has to keep in mind, I think it's safe to say, particularly for blind and print-disabled individuals, that within 3 years, our status as blind and print-disabled people really isn't going to change, and that it can be argued that we would be adversely affected by not having an exemption. So I think that NFB fully supports what Mr. Golden and others have already brought up, but there is something to be said about finding some mechanism where we can simply say we're requesting an exemption under the given rules. Now, not to bring up another point, I think it's important to consider where the burden of proof is right now. I think Mr. Ban made a really good point that this is more of an adjudicatory issue, but because of these are the circumstances that we have now, I think there is something to be said from shifting the burden from the proponent to the opposition. So I just wanted to make sure that that was clear, at least for people with disabilities.
Thank you. Mr. Geiger?
So it sounds like we've heard some more consensus than perhaps we'd originally thought on what meaningful opposition ought to look like, and that perhaps it should be something more like a change in circumstances. So I want to draw back to an earlier comment that I had made, which I know relates to also to the panel on the evidentiary standard, which is that in thinking about whether to renew a temporary exemption, it is our position that interests that do not have anything to do with protecting rights holders or making copyrighted works available, we do not think that those should be considered for denying the exemption. In addition, or at least have them as a very clearly carrying much lower weight. From the perspective of security researchers, most of the opposition that we have seen so far to the exemption that we had asked for relates to not at all to copyright. It is about safety, largely. So we have, for example, a vehicle practice. We're looking at cybersecurity flaws in vehicles with the goal of making those vehicles safer. We saw opponents talking about the possibility that owners of cars would circumvent emissions controls or modify their vehicles in a way that is not safe. These things are already illegal. In the last panel, it brought up, well, what about a hacker that says that they want to hack the nuclear power plant? That is also illegal. It's illegal under the Consumer Fraud or Computer Fraud and Abuse Act. By and large, at DMCA, what we're talking about are computers that the security researcher already owns. And copyright law and 1201 are not the appropriate tool to use to protect these non-copyright interests. There are already specific government agencies with greater expertise and in many cases already regulations on the books prohibiting these very same kinds of acts. So that is our position, that not accommodating non-copyright interests for the denying the exemption.
In the specific case of security researchers, 1201J is a permanent exemption, and I know you're going to speak tomorrow. I mean, is that perhaps a better avenue to just sort of update that to the extent it needs to be updated so that security researchers can rely on it as opposed to, tinkering with the whole mechanism of the rulemaking process?
100%, yes. And I mean, I'm in the same position as
Mr.
Butler, that we think that this is less preferable than updating the permanent exemption. Part of the problem with even a change in circumstances is that technology will evolve, security research will also evolve, it'll present new circumstances, probably not new circumstances related to making copyrighted works available, but new circumstances, new safety dangers, things like that. And those safety dangers should be dealt with by the agencies that are directly responsible for working on safety. So yes, 100% the permanent exemption, we have specific ideas on how to change it, and we can talk about that tomorrow or now if you wish.
Let's save it for tomorrow.
Sure.
Go ahead.
I just have a quick question going back to relying on the prior record from when the exemption was originally granted. Is there some point in time when relying on that old record would get stale? It seems maybe if you're relying on the record from 3 years ago, it might still be okay, but what about when you're 10 years, 20 years, because it keeps getting renewed without opposition? At least working within the current statute, it says the determination is whether users are or are likely to be adversely affected. So at what point is there some point when relying on that old record and a checkbox, does that become problematic within the current statute? Mr. Band?
So I would imagine that even after checking the box, that those of us, someone in Washington will show up at the hearing. And so.
I think we
so
don't
for
have the hearing if you check the box, though. I think
Well, no,
that's
no,
what
or
we're
consider-
right?
No hearing.
Well, right, or you could, I mean, it could be, you know, we can meet for lunch over in the cafeteria. And, you know, but it could be something very, you know, if there's a sense that there needs to be refreshing of the record, that can easily be done. It doesn't need to be, the point is, it doesn't need to be, we don't need to make this more complicated than it needs to be. Let's keep it simple. And so I think the idea of, you know, if you want to say, okay, let's have a quick hearing, you know, I'll come in on behalf of, you know, the education community, or, you know, I can wear it on behalf of the blind. I mean, someone can come in and we can talk about it and we say, are you still using this exemption? Yeah, we're still using it. You know, Rebecca can come in and say, are people still making remixes? Yeah, they're still making remixes. It doesn't need to be, you know, and the possibility, you know, so there's someone who can come in. It's just a question of, does Rebecca have to come forward with all these examples of remixes that have been made in the last 3 years, or does the NFB have to come forward with statistical data on the number of blind people who are making use of the exemption? I mean, it's that kind of burden, but, you know, it's a problem that can easily be addressed down the road if necessary.
I mean, the only thing I will say is, given that we have to have these as a triennial rulemaking, which means every 3 years, to have the short and then like the medium and then the long, I think could get complicated very quickly. So any reform, I think the office would want to make sure that it's not increasing the complexity of an already complex rulemaking. So I don't know if you wanted to speak to that.
Related to that, I mean, the other way, not only is it a matter of these renewals, but you could, again, in my interest of reducing your workload, you can reduce the number of categories or number of classes. So, you know, we've grown from one class that basically covered all educational uses and documentary films and remixes and non-commercial works, and now there's probably, I don't know, like 8 or 9 classes covering that. You know, we could go back to, or at some point come up with one class and just keep things simple. Certainly in the case of if you look at the, you know, of the 22 exemptions granted in this past rulemaking, more than half dealt with embedded software. We don't need to have 11 or 12 exemptions. You could have one, you know, properly crafted, would take care of that problem, and you wouldn't have to worry about regulating the automobile industry. You know, let someone else do that. That's not your job. And so, but the point is, you know, these things can work in tandem to really streamline this whole process.
Professor Tushnet?
So, Jonathan covered almost exactly what I wanted to say, but let me just reinforce that by linking it with Mr. Cazares' point, which is, you know, it's not just patterns of protected use classes that persist over time, but patterns of uses persist over time, which is why we talk about things that are, you know, non-infringing or categories of fair use. So people have really mapped those pretty well. Pam Samuelson, Michael Madison, they've done, and those can be expected to persist over time. In terms of, you know, don't complicate an already complicated rule, I think what we are saying is, you know, if you change the definition so that they're 44 words long, again, like they used to be, then you wouldn't, then even having a short, medium, and long form, which I don't think you should do, would actually represent a substantial improvement.
Thank you. So I'll call on Mr. Scheffner next, and I wanted to just tee up the next question, which is, how should we separate whether there's an administrative or statutory, you know, change dealing with new exemptions, you know, or new technologies, the expansions versus the renewal of the previously granted exemptions? Because I think, again, some of it is that technology does evolve, and this rulemaking process is supposed to be able to accommodate those evolutions.
Right, so I just wanted to address briefly Mr. Sloan's question about sort of stale old evidence. I mean, like Mr. Turnbull, we would not oppose the ability of proponents to incorporate by reference evidence that has been submitted in previous rulemaking. So is it possible that evidence could get stale? Yes, it is, but I think that there's largely a self-correcting mechanism, at least as I would envision a revised system, and it's this. So if a proponent goes in there and files their one page or one checkbox form, however it turns out, and they say, you know, and we hereby incorporate by reference all the stuff that we filed in the previous rulemakings, the potential opponents of that exemption will look at that. And in deciding whether or not they're going to oppose this previously granted exemption, one of the things they will ask themselves is, has the situation on the ground changed? It could be a change in the case law. It could be a change in business models. It could be that there's a new technology that enables you to do what you want to do without circumventing DRM. And it could be that the evidence that was submitted truly is stale and doesn't reflect the current situation on the ground. And if it is, and that would, again, what I think is going to be a very rare instance of opposing a previously granted exemption, they would have the opportunity to do it and say, you know what, we actually do have meaningful opposition here. We think the situation has changed for the following 3 reasons. And you know, they're actually the evidence they incorporate by reference is indeed stale.
Thank you. Did you also want to comment on the second question, which would be, what about a new technology? For example, if there's a petition for an exemption for 4K versus we're renewing something for DVDs, how should the rulemaking process deal with renewal of the previous exemption as well as consider some of the issues with a new petition?
Sure. I think I touched on this in my answer to your very first question this afternoon, and it's this. We would support a streamlined process for dealing with sort of renewal of the exact same exemption. To the extent people want to expand that exemption, I think they're, in a way, in practice, it may be streamlined because the part of the if you have an exemption, a previously granted exemption asks for this, and then the requested new exemption is this, what I'm saying is we don't have to fight again over this. But to the extent that they ask for this much more, yes, we think the burden should remain on the proponents of the exemption, and we'll go through the regular process about that. It'll be a lot smaller of a fight than having to fight over the whole thing. It'll just be fighting over this much. But again, the sort of streamlined part should only technically apply to exactly what was previously granted.
Thank you. Mr. Butler?
Yeah, so and I think that's largely true that certainly the presumption of renewal, that we've all sort of agreed on would not apply in the same way to an incremental increase. So going from the existing DVD and Blu-ray to 4K. But on the other hand, I would hope that some of the logic that underwrites that presumption logic that we've all sort of come to agree to would mean that process would, the arguments about 4K or whatever the new format is, could be a little bit shorter because we would all already agree that the planned use is lawful, right? Like if it's fair use with a DVD, it's also fair use with a Blu-ray, it's also fair use with a 4K. So that would already be established. And the adverse effect, some of the sense of what is the pedagogical use of media in a media class, right? All of that stuff would already be on the record. So hopefully it would be a much shorter argument about, why, if anything, what, if anything, makes 4K different from DVD or Blu-ray in terms of meriting an exemption or whatever.
Mr. Turnbull?
I actually think I agree with most of what you just said. I think from the technology provider, however, there is a substantial difference between a technology that is 10 years old and a technology that has just been launched, and the considerations. And we think that the Copyright Office should and has made with regard to new technologies and the harm to the development of the market. Again, going back to the original purpose of the circumvention provision of the DMCA, which is not merely to stem piracy, but also to enable new markets. And so the enabling of the new market for 4K may have a different dynamic than the situation with regard to Blu-ray, which is now 10 years old. So I think I do think that there is a substantial difference between, and you can't just sort of automatically apply whatever the reasoning was with regard to DVD and then Blu-ray and, whatever.
Okay. So Mr. Band, it seemed like Mr. Butler and Mr. Turnbull at least agreed on something. Do you want to undo that?
Oh, no. I just want to basically, and this is kind of very difficult for me to be in the situation of agreeing so much with Mr. Turnbull and Mr. Schaffner, but I just think, getting back, one of the things that you can do in building on, the issues that Bruce has identified is that in this process, the Copyright Office can help manage, and again, with the aim of reducing your workload. Okay, by now what the issues are in general terms with, this whole DVD, Blu-ray, educational use, remix use, and so forth. So, one can easily imagine that, there's going to be, we'll make, say we want to renew, plus we want to expand. And then they'll say, well, we have no problem with renewal. Okay, we have this issue with expansion. And then, there could almost be like a pre-hearing conference where you guys say, okay, this is what we think, we want to hear this, we want to, where you can sort of iron out, figure out what it is that you need to know from us, and that way it could ultimately reduce our burden with respect to renewal. But the point is it can reduce your burden as well. We're talking, in terms of what's being renewed, we're talking about a relatively small universe of things that we know now we have been through, so that this cluster of the motion picture related issues, the issues with respect to the screen readers, maybe one or two others. And so there's nothing, I don't see why you can't have at some point in the process a meeting with us where we kind of say, okay, what is it that you need more, and what is it that we're going to give you more? And so that way it will just, instead of, again, sort of like reinventing the wheel, we can really move the process along dramatically.
So it sounds like you're saying, short of a statutory reform, if the office provided some guidance as to, what quantum of information we thought would be useful for the registrar to make the recommendation to the librarian, in advance, or maybe sort of iteratively working with the parties, that could be helpful to streamlining this and avoiding for the renewals, the type of rulemaking process we have for the new petitions.
Yeah, no, I think that's right. But again, I'm trying to push you to be a little more informal, and I think that could make the process work a lot better.
Thank you, Mr. Butler. Anything to add? Or?
I just wanted to add that the flip side of what Mr. Turnbull was saying about, when a format is young, the market realities about that format will be thus and such. And there will be, of course, a mirror image on the side of the proponents. When a format is young, the kinds of harms that we've typically shown for young formats are, there are these titles that are not available on the, right? And we're told, like, well, that's just one or two titles. Well, that's because it's a young format. So there's an interesting mirror image thing that happens here, and maybe these young formats really will benefit from getting their own kind of hearing where all that stuff can come out.
Thank you. Mr. Schaffner, did you want to add something? Oh, nope. Okay. Mr. Turnbull, good?
Yeah, I mean, we're having this wonderful agreement session here. I think that what Mr. Band was talking about would make sense and would be helpful in streamlining. I mean, I think that, again, and and getting and having some kind of process with the office to sort of work with the parties to say, okay, what makes the most sense to have a hearing about would make sense. I did want to comment just briefly on the nature of the rulemaking, and this has always been sort of a hybrid in a lot of respects between the sort of adjudicatory model and the notice and comment rulemaking model, and it seems to me that that's sort of inevitable in the process because I think it's unrealistic, and nor do I think Congress thought that it was going to happen, that the Copyright Office would go out and know what 200 million people might be doing with any given copyrighted work. And so the people who have the need and to use something are the people with the information to come forward and say, this is how we want to use it, and this is why this is a problem for us. And at the end of the day, the Copyright Office has the obligation to come out with a rule that reflects the evidence, notwithstanding the comments about the Commerce Department report, I think that is very instructive still. They talked several places about evidence and about a record and that sort of thing. So I think that having evidence in the record is an important element of this rulemaking. But in other respects, it doesn't have the sort of adjudicatory feel to it. One of the comments that was made earlier, I think, Mr. Williams, about the possibility of then having a proposed rule, put forward would then sort of maybe complete the cycle. That would then feel more like the notice and comment rulemaking. But all of the rest of it leading up to it would be fact-finding that the office would need in order to know what to put forward in a proposed rulemaking. And we would be okay with that as a process. I mean, we're okay with the process mostly as it is. But.
Thank you. So the next question, I feel, will probably spark dissent. One of the participants, ESA is not on this panel, had suggested a streamlined process for rejecting a proposal, saying, just as we renew exemptions, we also end up rehashing the same proposals over and over again that are consistently recommended against. Should we have a similar streamlined proposal for, a second bite at the apple of something that was denied?
So a couple of things. I mean, in general, no, in part because the copyright owner always retains the ability to go to court and hash that out and win either on contributory infringement or infringement, depending on what the activity is. And that would end the exemption and end it next time. Whereas if you lose, you just don't get that chance. So it's structurally unequal in a way that makes mirror image treatment inappropriate. The other thing, though, is that considering this rule, again, requires you to consider the way that all these little additions have been piled on to specific exemptions over the years. So does that mean, for example, are you proposing that we could not go back to the 44-word initial educational exemption? That seems to me like a bad idea. Just because it's been loaded down with other things doesn't mean that the initial exemption was inappropriate, even though in some sense it's been rejected. And I think the kind of line drawing that you would end up doing would be contrary to the goal of simplifying things.
Thank you. Mr. Band?
I guess I would add to that a problem with sort of like a streamlined rejection is that the circumstances do change, and I suspect also that rights holders get more comfortable with certain kinds of activities, and so just to if a proponent is willing to go to the work of amassing new evidence, then the rights holder, if they're confident that their arguments were sound before, they can, certainly they can always incorporate by reference and say, well, all the argument, these people haven't said anything new. So it's not, we're not streamlining the process, but, once you make it clear it's okay to incorporate things by reference, or if they want to, resubmit the same thing. If it really is just the same thing all over again, then, the arguments as to why it wasn't valid before would apply now. Whereas in our situation, it's different because we have to, right now you're basically telling us that we have to de novo show that we're going to be adversely affected. So we have to come up with sort of like new examples of how we're using or how we've been using it in the last 3 years as opposed to previously. So that's why the symmetry, it is an asymmetrical situation. So certainly it could be done in a way, you can make it clear that there are ways, if they want to incorporate stuff by reference, that's fine. But still, the need for a streamlined process, I think, is very different.
Mr. Butler, do you agree?
Largely, yeah. I think the key thing is just, the incentive to, the difficulty rather of seeking an exemption that has not been previously granted is high enough, I think, to deter folks from, that's enough of a burden that you had better really want it and really believe it. And so, I think at that point, those folks should be able to get into the process. And the people who don't have enough of an interest will be deterred by the difficulty of doing it.
I mean, you would be surprised, sort of. We do get a lot of repeat players.
I have a quick question. Just want to go back to the issue of meaningful opposition and what that would mean and what would need to be shown in those circumstances. So we had talked about, showing something either that the exemption's not being used, or there have been changed circumstances or harm or something to that effect. But I wanted to get your positions on how much evidence, how much opposition would be needed. It seems that if you had something like a preponderance standard and the proponent is just checking a box saying unchanged circumstances, it would be could be a pretty minimal showing to oppose that. So I'm just want to get your viewpoints on where the line should be that would make the presumption meaningful, in that the opposition needs to have something fairly substantive, but then on the other side not be a huge burden then on the opponent, such that you could never really oppose the presumption, where that line might be best drawn.
Sure. Well, I think, and you can correct me if I'm wrong, but you were saying that the proponent, sort of their very short showing, is going to just sort of say, like, the check the box, or the opponent, to kick that back, is just going to have to overcome the check the box?
Right, to get to more likely than not against a checked box would seem pretty minimal. So I'm just trying to see where the line might be to give both sides.
Absolutely, and I think certainly Isri, and I'm sure many other people on this panel would want the Copyright Office to be considering the past evidentiary record, and have that form the basis of whatever the determination of meaningfulness the Copyright Office comes to. So I think it's really hard to decide this question without having a super clear idea of how much of that evidentiary record is kind of just pulled into this new discussion versus the proponent having to say affirmatively, we've shown this before, here it is again. But I think our position would definitely be that the meaningful opposition would have to show some kind of significant change in circumstances such that the prior evidentiary record is overcome to some degree.
Thank you. I think we're going to try to do one last round in the spirit of efficiency that we've been talking about. We can maybe end a couple minutes early. Mr. Band?
Well, I guess the way I would respond to that question is I'm not sure you really need to specify the exact precise level of how material the opposition is or how significant it is. If Mr. Turnbull or Mr. Schaffner's client, if they make a submission as to why something should not be renewed, you'll look at it and you'll decide whether it is material or whether it has weight or not, and then you'll decide whether to kick it over. Because this is all going to be, and I'm not sure how there would ever be a possibility of us challenging your decision whether or not to kick it over, right? Whether to put it in the streamlined process or the other process. I think it would be very hard for us to come up with a court challenge. So given that you're going to have a fair degree of discretion, it's going to be very hard for us to show that you somehow abuse your discretion, you know, going in one way or the other. I mean, it would have to be pretty blatant, like, oh, their band goes again, let's, you know, screw him. You know, but barring that, I don't think it would be very, you know, so I don't think it, again, I think let's keep it simple. Let's not make it so complicated that we get tied up in standards and burdens such that we, you know, don't move forward. I think we're in a position where we can move forward pretty easily and not worry about those, you know, those nuances.
Mr. Schaffner?
Yeah, I largely agree with what Mr. Ban just said. And just to respond to Mr. Sloan's question about sort of what meaningful opposition would look like. You know, we were not terribly specific in our own written comments about exactly how the process should work. But let me just sort of spell it out how I envision in kind of non-legalese. I mean, what I envision is essentially a sort of pre-screening process that the Copyright Office would employ before delving into sort of the regular process that we've all gotten used to over the last 6 cycles or so. So the initial step would be the proponent of a previously granted exemption filing something short. We can argue about whether it's a page or a checkbox or a paragraph, whatever. And then essentially what the Copyright Office is going to be asking itself, or should be asking itself, is, do we have a real fight here? Do we have a real fight between sort of 2 sets of arguments, or do we have essentially an unopposed request for an exemption? So the opponent of the previously granted exemption, again, in this rare case where someone is actually going to come forward and oppose a previously granted exemption, I would just say, again, it's going to be a 1-page form, and they're going to identify why there is meaningful opposition here. Is it because there's, you know, a short description? There is a change. They've discovered that there is actually great harm, or consider, you know, significant harm from the previously granted, from the exception to the prohibitions in the DMCA. Is there changed case law that would touch on whether or not the use at issue was non-infringing? Is there new technology that would make possible what the proponents want to do without circumventing the DRM, that kind of thing? Again, a short form that allows the Copyright Office to look at it and say, you know, do this pre-screening and say, do we have a real substantial fight on our hand, or is this essentially, you know, a no-brainer where there's no significant, no meaningful, whatever the right word is, opposition? And if there is, then again, it just gets shunted back into the regular process.
And then would you think if the office in its pre-screening determined it was sort of insufficient under administrative law principles or something, we could go back and say, give us a little more, like Mr. Ban was saying, or?
Yeah, I mean, again, we haven't specified a whole set of processes, and like Mr. Ban, I wouldn't want to make it too complicated, but I mean, I think at a high level, that's what, I mean, I just explained what I think the Copyright Office should be trying to do is screen out, okay, do we have a real fight here, or do we not? And again, in the vast, vast majority of cases where somebody has gotten an exemption already, there is not going to be a real fight. There's not going to be an opponent who's shown up. And they're not going to bother to show up unless they really, really have a good reason that I'm sure they'll be able to identify in a page or 2.
People will probably hold you to that. Just kidding. Mr. Turnbull?
I would agree with that, and only add that I think that the nature and quantum of evidence that would need or argument that would need to come forward will depend a bit on what the previous grant was. If the previous grant is, this is really a close case, but we think that, you know, it's okay, you know, and we'll go forward, then you may not need as much to come back and say, yeah, there is a real argument here. If the previous was, you know, if it's already been granted 3 times and this is the 4th time around, and it's just clear as a bell that the opinion, the recommendation is really clear, then it's going to take more to come back and say, no, there really now is a new argument. There really now is new evidence or whatever. I just and again, I think that, I'm agreeing that it'll be in your discretion, but I think that the level is going to be, it'll be pretty apparent in any given case. And your question about if somebody submits something and you go, well, on its face, that really doesn't do it, but we're not quite sure what you're getting at, I think that you ought to have the discretion to go back and say, you say that there's new case law, or you say that there's some new technology, but you're really not describing that. If we're going to reopen this, into a full evidentiary hearing, we need more than that. And maybe not extending it out a long time or giving, repetitive, but it seems to me that you would have the discretion to do that. I would hope that the lawyers representing the opponents would come forward and do well in the first instance, but if there was a question, I think that it's within your discretion to ask for more.
Thank you. Professor Tushnet?
So just briefly, I wanted to talk about the characteristic or the characterization of checking a box as like somehow not meeting your burden. I mean, I don't think that's just checking a box any more than when you check a box saying you've submitted truthful information on your tax return, that's a meaningless or trivial act. It's an affirmation that the conditions at issue continue to exist or exist in the case of the tax return. So it seems to me that in order to refute the checked box, you should have to show those conditions and laws have changed, just as the IRS would want to show that, in fact, that wasn't your income. And if you want me to, I will submit the entire record from the last 3 rulemakings as attachments so you can consider them submitted. But that seems kind of trivial. I mean, I would be happier if you considered the checkmark to be me making that submission. If we all agreed that that was what I was doing, then it seems to me that we then have a full submission. It's just one that's already in your books.
Thank you. Mr. Geiger?
So in this renewal process that we're talking about here, we've talked about having a one page of why of meaningful opposition, of why circumstances have changed, and if the Copyright Office then in its discretion decides that it is in fact meaningful, then they kick it over to the normal process. I would, unfortunately, it would be a more complex process, but I would suggest that in between those two actions, you actually give the proponent the opportunity to respond. The proponent the opportunity to say, no, the meaningful opposition is not meaningful, and here's why. Because otherwise, and hopefully that will inform the Copyright Office to better exercise its discretion before beginning the long and laborious process of going through the whole temporary exemption again.
Thank you. Mr. Butler, I think you may have the last word.
Yeah, so it's getting complicated now, isn't it? The one-pagers are proliferating, which is good for those of us who bill by the hour, but I don't anymore. So, I wonder. Ultimately, I think I guess this may be too obvious to say, but ultimately, the folks who oppose, I think, are going to have to come forward with some real information to explain why they think circumstances have changed. And so I don't know, I just wonder how useful it is, unless the office is willing, I think, to say based on a one-pager, and the opponents are willing to be judged based on a one-pager, like, no, we're going no further, that's just not enough, we're not going to listen. Then perhaps the opponents should just go ahead and come forward with whatever reasons they have, like the full bore, because otherwise, how do we know what those reasons are, and how do the proponents respond, right? So if there is information that the opponents have, maybe they should go ahead and disclose it, or else, again, maybe we can all agree that sometimes that one page will just be on its face lame, and you can reject it, and then maybe the one-page thing is a good idea, as long as everybody's okay with being killed at that stage and not going forward to the full thing.
Thank you. Well, we are 2 minutes early, so I'll consider that a minor victory. And this panel is concluded. Tomorrow we start again at 9 in the morning talking about the anti-trafficking prohibitions.
This has been a presentation of the Library of Congress. Visit us at loc.gov.